The very language of law is undergoing a massive shift. Contracts, court orders, all those official decisions, they're not just stuff on paper anymore. In this explainer, which is based on the works of Professor Vihar Kiskanov, we're going to break down the framework for understanding legal statements in this new virtual world. Think about it. For hundreds of years, legal facts were all about physical paper. But now, well, they live inside electronic registers and databases. And this isn't just about switching from a filing cabinet to a hard drive. No, it's a deep, fundamental shift in how the law actually operates, moving from the physical world right into the virtual one. All right, so here's what we've got on the agenda. We'll kick things off by defining these new types of legal statements. Then we'll dig into how they're actually formed. After that, we'll get into the really critical rules that keep them in check, and we'll wrap it all up by connecting everything to the huge new EU AI Act. Okay, first things first, let's get our key terms straight. If you're going to navigate the law in this digital age, you absolutely have to understand the new ways a legal will, and intention can be expressed, because it's definitely not just about a signature on a piece of paper anymore. Let's start with the one you're probably most familiar with, the electronic statement. This is pretty straightforward. A person, or maybe a company, decides to do something and just uses an electronic tool to make it happen. Like emailing a signed contract as a PDF, or just filling out a form online. The key takeaway here is that a human being is 100% in control of both the message and the meaning behind it. Next up, we have automatic statements. Now, this is where things get a little more interesting. Here, an IT system is actually generating the statement itself. But, and this is crucial, it's only acting on rules that were pre-programmed by a human. A perfect example? That order confirmation email you get the second you buy something online. The company's intention to confirm your purchase was already written into the code, way before you ever clicked that buy button. And that brings us to computer statements. This is where the human is taken out of the immediate loop entirely. We're talking pure machine-to-machine communication. One IT system sends a message to another, and it all happens based on rules set up in advance. This is the real engine powering things like automated stock trading or smart contracts talking to each other on a blockchain. Finally, there's this really fascinating and complex new category, the hybrid statement. This is where a human and an IT system basically act like partners. For example, an AI could crunch a ton of data and recommend a certain decision, but it's still a human who has to make that final call. And this kind of teamwork, well, it really blurs the lines of who's legally responsible, which opens up a whole can of worms at some tough new questions. Okay, so let's circle back and dig a little deeper into the most basic form we talked about, the electronic statement. Remember, this is the one where the human is still firmly in the driver's seat. So what makes them tick? Well, the key features are pretty straightforward. They're made by people or organizations. They exist in an electronic format, and you can send them to another person or even directly to a computer system, like when you fill out a form on a website. This really covers the whole gamut, from complex e-contracts to something as simple as a lawyer uploading a document to a court's online system. All right, now things get a bit more complicated when we start talking about automatic statements. I mean, what happens when a machine starts making legal declarations for us? How on earth do we justify holding a person responsible for what their algorithm decides to do? Well, around the world, the law has come up with two main ways to handle this. Over in the US, they use this idea of an electronic agent. It's kind of like a legal shortcut where the machine is just treated as an extension of the person who coded it. Meanwhile, in Germany, they use what's called the risk principle. The logic there is, if you're going to profit from a potentially risky automated system, then you've also got to be responsible for what it does. So even though they get there by different routes, both legal systems land in the exact same spot. The human operator is still the one on the hook. And you can see this exact legal mindset in action in a major court case out of Singapore. What happened was a trading algorithm went haywire and made a mistake, but the court ruled the contract was still valid. Why? Because, as they put it, the parties' intentions were objectified in the code. In other words, the court basically said the code was the final word. The program did precisely what it was programmed to do, even if the result wasn't what anyone expected. This all naturally leads us to computer statements and the incredible rise of these truly autonomous systems, where machines are talking directly to other machines without a human needing to step in at all. And here we see a huge clash of philosophies. In the tech community, you hear this mantra all the time: code is law. The idea is that if the code lets you do it, then it must be okay. But the legal reality? it's a whole different story. The law is very clear. A smart contract is just a tool for enforcement. It's not its own legal system. And that means that even a blockchain transaction that's supposed to be irreversible can absolutely be challenged and overturned in a court of law, based on age-old principles like fraud or a simple mistake. So, with all this automation happening, it begs the question, what's there to protect us? Well, that's where the digital guardrails come in. These are the crucial rules and restrictions put in place specifically to protect our basic rights in this increasingly automated world.
And right at the heart of these protections, especially if you're in Europe, is one single incredibly powerful rule. We're talking, of course, about Article 22 of the GDPR.
So what does it do? It gives us a fundamental right, the right not to have a decision made about us based solely on automated processing, especially when that decision has major legal consequences. It's designed to stop things like, say, getting automatically rejected for a loan online, or having an AI hiring tool toss out your resume, all without a single human being ever looking at your file. But this right isn't set in stone. It's not absolute. There are 3 major exceptions you need to know about. The rule doesn't apply if that automated decision is essential for entering into a contract, or if it's specifically allowed by a law that has its own built-in protections, or, finally, if you've given your clear, explicit consent for it to happen. All right, for our final section, let's pull all these ideas together and see how they connect to what is arguably the biggest piece of tech regulation on the entire planet, the EU's Artificial Intelligence Act. Now, what's interesting is the AI Act doesn't actually use the exact terms we've been talking about, but the underlying concepts are absolutely everywhere. Think about it. An electronic statement is just like when a company has to register its high-risk AI system in the EU database. An automatic statement, that's like the AI system generating its own logs for the authorities to check. And a computer statement is a perfect parallel for when that EU database talks directly to other government IT systems. It's a fantastic real-world map of the theory we've been discussing. So what about the new kid on the block, generative AI? Let's say you ask an AI to draft a contract for you. Who's on the hook if it gets something wrong? Well, the legal world is pretty much in agreement on this. The AI is just a sophisticated tool. The person who writes the prompt, who looks over the result, and who decides to use that text, that's the person who is 100% legally responsible. So what have we seen? While technology is constantly inventing new ways to make legal statements, from simple electronic messages to fully autonomous systems, the law keeps pulling that thread of responsibility right back to a human. The user, the programmer, the operator. They're still the ones who are held accountable. But all of this leaves us with one final, really big question to think about. As AI starts generating our contracts, our legal arguments, and maybe even our decisions, who is it that's truly holding the pen?